Okay, so we are on the record in Bong versus Douglas Educational Service District. That's 25 CV 45435. This is the time set for a trial readiness. And I realized that only recently did a court order for discovery go out, and it gave a time frame that would potentially move beyond what the current trial date is. Are any of the parties concerned about that making a problem?
I'm not sure what the court order is, Your Honor.
Where is it?
I also am unaware of a court order when I was looking at eCourt yesterday, but I've not checked this morning.
Well, yeah, I don't see it. What happened? Because there was a motion for
Motion to compel.
compel, yeah, and I generated an order from it, and nobody got it.
No, Your
And
Honor.
I don't see it in here. Oh, okay. Now, what I will say is that I did do it later than I meant to, because there were just a lot of motions, and I dealt with 4 or 5 of them in one letter, and then I got a note. Hey, this is past 60, or it's getting up on 60 days. I don't think it was because of when the thing was, but it doesn't matter. I did, in fact, do the order. Well, okay. So you wouldn't have a clue whether that will take you any time, because you don't know what it's ordering you to disclose.
Yes.
Okay. Because it wasn't just, the court did not deny it outright. That there was an order that said these things need to be discovered and subject to privilege or whatever. But there was definitely an order that wasn't just no. It was ordering some things. Okay.
And then we also have to look at how that would interact at future discovery attempts that have been going back and forth.
Sure.
Of course, I have no idea how it interacts with any of that stuff, not having the order.
Yeah. See, and I thought that y'all had got it because there was a motion to shorten time. I thought it was dealing with that.
And that's dealing with a request for admission that was at the beginning of this week.
Okay. I am utterly at a loss. Let me take a look. Maybe I can get to it. I still don't understand what happened to it. I spent quite a bit of time just writing that whole thing up, and now it's MIA, and okay. Remote.
Is it the letter? Or?
It is
a letter. There have been a couple of them in this case.
Well, in this case, it wasn't me writing a letter. It was actually an order. Okay, I don't want to have everybody just sitting here while I try to figure out how this works. So what I can say is that there was an order to compel. I know I did it. That said, yeah, it's right there. There's the notice. Okay, so the notice pertaining to it, this is from Ms. Bong saying, hey, it looks like it's past 60 days. And it was, I believe, within a day or two, I had written the order, and maybe, I don't think I had an accompanying letter. I think it was just the order with the findings, and had signed it. So how do I remote back to my own desktop? Otherwise, I'm going to have to run down and get it. I'm not seeing that. There, remote desktop. Finish. Now here I should be able to get a hold of it. Yeah, it looks like a. Okay, so I wrote a letter and I did a order, so it's both. Where's the? So I'm not sure what happened with it. Huh. Well, it's going to be impossible for them to comply with. I don't know where it is. I mean, I don't know what happened to it. It's right here on my computer, but I don't know why it was not sent out to the parties. I mean, I can print a copy for everybody, I guess, and so that way you'd have it right now. What a mess.
Miss Bong, who couldn't receive a printed
No,
copy, right?
I mean, we'd be mailing it to her, I guess. I'm just really irritated that didn't somehow work its way into the file or get sent out, because everybody's saying they didn't get it. Although it was mailed out probably on it was probably mailed out Monday because I finished it Friday. So it may just not have arrived yet. However, it should also still be in the file, and I'm not seeing it in Odyssey, so that's going to have to.
I'm also not seeing it in Odyssey.
Yeah. Okay, so. So you'll be getting it in the mail, I'm sure.
You want me to email it to them?
Yeah. Yeah, can you email it to him? It won't be a signed version, probably, but wait, what are you going to email to him?
Your letter?
Okay, and how are you going to get it? Because it's.
You can send it to me by email. And then
Yeah, I can do that. Okay. It's always something.
So, Your Honor, if Mr. Hodovic's able to produce the compelled records in the before trial, I'm wondering if either we can, take a short recess before trial for me to go over them, or before the, depending on what records were compelled.
Yeah. The issue is that the motion to compel sets the deadline to provide what is listed after the trial date. Like, because to allow enough time for that to be done, the court said 15 days or 14 days, whatever it was, but that's still past the trial date regardless, even if he'd got it the same day.
Right.
That's why I'm asking, do we need to move the trial date? The upside, if we need to do that, would be that since it's not a jury trial and it's only set for a day, we could probably just move it a little ways further down in the month and still be not way off time. I don't think it would be devastating to the calendar. And that was actually what I thought we were going to be discussing today. I didn't realize that nobody had seen this thing. So, okay. And did you get that email?
you need to make sure it's-
Okay, so we're going to be emailing you the letter and basically an unsigned copy of the order to compel. I don't know what the parties are going to think of. Well, that'll take me forever, or I can do that this afternoon. I don't know, because I don't know what I'm ordering is categories, not individual documents, because I wouldn't know that. So until Mr. Hodovec has a chance to look at it and go, oh, well, that's easy, or, oh, well, that's impossible, I don't know that he has a timeline that he would be able to promise.
And I'm sure I'll have to confer with my clients to get their
Sure.
on, do we have any of this stuff, or is it all privileged, or
Yeah, exactly.
combination thereof?
How much is being actually discovered? I don't know. I mean, because I don't know that information. I see that we are set for trial, though, on Wednesday, and that seems really optimistic. That would basically be, well, there is nothing to discover, and we can just say that.
Mhm.
But if there is any other answer, I don't know how the parties would be able to adjust within a week. I mean, that just seems really demanding. So what I thought we might do is to reset trial out a couple of weeks to allow that discovery process to occur. Because the court did set a deadline on this that's pretty quick. And I don't know if like setting this to the 27th of this month would be something where the parties are available. 'Cause
Give me a moment, Your Honor. I have to check my calendar.
Yeah.
Can we get her to complete her email address?
Oh, and Ms. Bong, can you confirm your email address for the clerk?
Yes, it's Mars in Motion. So it's MARS Z as in zoo INMOTION @yahoo.com.
Okay, it seems to be that's what we have. So you should be receiving that email with at least the unsigned versions of what you were mailed, so that you can see what it is the court did with that. So if we reset this to the Mr. Hodovec, does the 27th work for you?
So I'm available. I have to confer with my clients to make sure that
Sure.
they would be available, witnesses, so forth. Would we be able to, I guess, push it a little further out? Also, would be hoping I could file another motion for summary judgment. And so after our last motion for summary judgment, there was another case where Ms. Bong suing the Douglas Education Services District over a different request, public records request.
Mhm.
There was a motion for summary judgment from Douglas ESD's side in that case, and that was granted at the end of last month. And so I would be looking at a new motion for summary judgment on claim preclusion for similar facts to
Like a res judicata type?
Yes.
Oh, okay.
It wouldn't be. It would be a partial motion for summary judgment. There are a few things different, but it would vastly narrow the scope of this case. And so, given that there weren't 30 days after that before trial, I wasn't able to do it in the meantime. But if we're going to
okay.
reset anyways,
Yes. I don't see any option but to reset.
Your
Go
Honor,
ahead, Ms. Bong.
that case is not res judicata or claim preclusion because I intend to appeal that summary judgment.
Oh, okay. And what I can say is, if we need to set there has not been a filing for motion for summary judgment, and we still do need to reset this for trial, as if there won't be one filed, because until it is, it isn't.
and if in my research in the meantime and preparing it and realize that it's not
gonna work.
available, then I won't file it.
Yeah. So we're not going to assume one will be filed. So I'm not going to set
It's like the time
hearing
to
on
do
this.
so if we are resetting it anyways.
And this is this isn't like child custody or someone's in jail. So it is not as urgent as some other matters might be. I don't necessarily have an issue. And also, I'm not going to have to worry about a jury going sideways on me. What I'm looking at then, how about, for example, April 17th?
I think I might have a medical appointment on the 17th.
Okay. Alternately, we also have the 21st.
That should be okay, I think.
Which?
April 25th, if Mr. Hodovec is available.
Just 21 April?
Wait, April 20.
Oh,
Yeah, that should be okay for my end. But I might have to get back to the court if there is actually something else, because I have quite a
That's
few
always the
minutes.
case. You can, yeah, if you need to file a motion to continue, like I said, this is not a jury case, so we're not going to be as intense over exactly what day it happens. Mr. Hodevec, does 21 April work for you?
It works for me. Same caveat of we'll have to talk to my
Sure,
witnesses.
sure. Yeah, I get it.
Huntington,
It's
yeah.
fine. Especially if you can confer with one another, with Ms. Bong, then if you can get a position on moving it to another date, sometimes that makes things quicker. Anyway, 21 April, we will set it at 9:30 in the morning. We'll set it for the whole day, but I'm starting to suspect this may not be a full day trial. We'll see. Because we're not having like voir dire and a lot of other time-consuming parts.
it being a
Also, Your Honor,
fairly
I'm sorry.
simple factual.
Yeah, it really does sound like it
We're
might
kind of
be.
all agreed on what the facts are. For the
Yeah,
most
I'm not
part.
sure that there's even wildly different facts. Ms. Bong, I'm sorry, we cut you off.
Yeah, I'm sorry. I did subpoena Miss Van Drimmelen to appear as a witness, as well as the superintendent and IT director for the 11th. Will I need to resubpoena them? Or will Mr. Hodovic be able to just inform them that it has been changed till another date?
Mr. Hodevec, do you have a position on that? Extending the subpoena?
I'm only aware of one subpoena being served.
Yeah.
And that was on Miss Van Dremlin, who I will be calling as a witness, as she is the main fact witness in the case.
Yeah. So basically the two choices are we can leave the trial date on and then they can show up and I can order them to,
Yeah.
or we can come up with something else. I hesitate to have Ms. Bong because she doesn't need to resubpoena them. If she's served the subpoena, then they can come in and I can order them to turn up on the 21st.
I will let Miss Van Dremlin know because she's the only one that I'm aware of having been served a subpoena, that the new trial date, and that she will need to be there under that subpoena. If either of the other two have also been served, I will give them the same instructions. But if they've not been personally served yet,
If they've been served under oral CP 9B through Mr. Hodovic, because they are director and officer of the ESD.
I got the subpoena ducis tecum, but that's if you want them to personally appear, they have to be personally served.
I do not believe that is the case, but I will look through the rules again, and I will serve them if need be. But that would, I guess, depend on the trial date as well. Yeah, the rules and the trial date.
Okay, and I don't know what's been done, so I'm not going to make a ruling on that. Maybe it's best to just leave the 11th on as a status check, and then I can order them to appear at the next date if they've been served.
I mean, if
seems
we'll look at the rules, we'll confer. If they have been served, I will let them know they need to appear at the next date. If they have not been served, then they haven't been served, and so they wouldn't have to show up at this date either.
Well, that's true. Ms. Bong, does that work for you?
I have no objections. I'll email Mr. Hodovic on that if that's okay with Mr. Hodovic.
Yep, that's totally fine. You can always email me.
Thank you.
Okay, so we've got a date. It is 21 April for trial. Let's go ahead and set a trial readiness on just to make sure everything's going smoothly, and especially the discovery issue. And how about 16 April at 8:45?
That would
and
be
the
fine.
parties can appear as they're appearing now. What?
Could I appear remotely, Your Honor?
For the 16th, absolutely.
Yes.
No problem.
And
8:45?
Yes, 8:45 for
also-
trial readiness.
Also, before we go, may I also seek leave to bring in my laptop for the trial itself, whatever day that is?
Yes, actually, I'm not aware of even needing to do that, but you may absolutely bring your laptop. If security gives you any static, just have them ask me, and they should be able to hunt me down.
Thank you, Your Honor.
Yeah, generally that has not been a problem with people bringing in laptops. I haven't seen anyone challenged on that.
Okay. Yeah, I had one a couple of years ago when I went to see.
Yeah, the rules have kind of changed in the last year or two. That's for fair. That's certainly true.
Okay.
Yeah.
Thank you, Your Honor.
Not at all. All right, thank you, everybody, and we will. Oh yes,
Just gonna look to see. Thought we had some more outstanding motions that
there
we
should.
should address to make sure everything's.
Is there
Okay, so
something
we'll-
else that the court needs to address before trial?
So going through the list that I have, there was a motion to shorten time for the request for admission. I think that's moot, given that we are now more than 30 days out from.
I would say that that's probably moot. Because there's more than 30 days before trial, so
There was
I think we're good there.
request for judicial notice, which I'm not opposing, although I'd probably just ask that judicial notice be taken of the whole case rather than specific parts. That was filed.
Case in terms of what's filed?
Yeah, then that's for the 24 CV case that I may be filing a motion based on.
Okay. Yeah, if there's no opposition to it, the court can take judicial notice of its own filings or its own cases. That's always true.
Then there was a motion in limine.
Oh.
That was filed by Ms. Bong on the 17th
of
February.
Oh, okay. Hang on. 17 February, motion in limine. There we are. And that is regarding... I don't know that needs to be dealt with ahead of time. It's going to be a court trial.
Mm-hmm.
So Ms. Bong, the motion in limine to exclude or limit evidence, the court's not allowed to rely on certain types of evidence. And given that there won't be a jury, I'm not worried that the jury is going to be poisoned by having heard an argument over admissibility or what was it? Like the relevance of certain things. I'm not allowed to rely on irrelevant evidence, and if I did, I'd be subject to appeal. So I don't know that we need to deal with that in advance of trial. If something is brought up, you can either argue against it or argue it should not be admitted. But I'm not concerned about jurors hearing evil during a court trial. So, yeah. So you're certainly welcome to re-raise those objections should that come up, and the court would rule on it at the time. And like I said, I'm not as worried about what a juror might hear as I am when it's just a court. The court has to hear the bad thing anyway to decide if it's admissible. So, so I think that motion in limine is also, I don't want to say it's moot, but I think we can deal with it at time of trial.
Yeah, if it becomes necessary. If the evidence is brought up that's being objected to, yeah.
Right.
Okay, I think those were all the open motions that I just wanted to make sure we addressed.
Ms. Bong, are you aware of anything else we need to deal with before trial?
I don't think so, Your Honor. Honestly, if the discovery produces enough evidence, we might actually be able to move to summary judgment, in my view. So, given the
who knows?
Yeah,
we will let you all decide that if you want to file for something like that. We'll deal with it as it comes up. But at this point, we are set for trial, and we've got our trial readiness. And yes, Ms. Bong, you can of course appear remotely for the trial readiness at least.
Thank you, Your Honor.
And actually, Mr. Mahodovec, you can too if you care. I just know you're across the hall there, so probably not gonna. All right.
I appreciate the option. I like being in person.
All right. Well, we'll see you then. Thank you, everyone.
Thank you, Your Honor.
Thank you, Your Honor.